Welcome to our panel on international humanitarian law issues in the context of the Israel-Gaza conflict, the fourth in a series of panels on current topics in international humanitarian law, sponsored by the American Society of Law's Lieber Society and co-sponsored by the DC Bar International Law Community. This series begun in October 2023. The three earlier sessions are available on the ASIL website or on YouTube, aims to foster substantive civil discussion and debate of IHL topics and to educate practitioners and others about the principles of IHL. I'm Marianne McGrail on the executive committee of the Lieber Society. And the Lieber Society, as you may know, is named after Francis Lieber, who in the first modern codification of the laws of war in 1863, commissioned by President Lincoln, wrote, "Men who take up arms against one another in public view do not cease on this account to be moral beings responsible to one another and to God." So we'll begin with brief introductions from our distinguished expert panelists, then a discussion, and then open the floor to questions from the audience. If you have a question, please post it in the Q&A rather than the chat. And this session is being recorded. So we understand that these issues are controversial, and our purpose, as I said, is to foster civil substantive debate. Please bear that in mind. Dr. Sherry Krebs, our first speaker, is a professor of law at Deakin University and co-lead of the law and policy theme at the Australian Government Cybersecurity Cooperative Research Center. She's also an affiliated scholar at Stanford University Center for International Security and Cooperation, and she is chair of the Lieber Society of ASIL. Leela Sadat is James Carr Professor of International Law at Washington University School of Law and was special advisor on crimes against humanity to the International Criminal Court from 2013 to 2023. I hope I got those dates right. Please correct me if I didn't. Omar Dajani is Carol Olson Professor of International Law and co-director of the Global Center for Business and Development at the McGeorge School of Law at University of the Pacific. He is also co-chair of the board of A Land for All, an Israeli-Palestinian peace movement. Lauren Voss is the National Security, Cybersecurity, and Foreign Relations Law Fellow and Visiting Associate Professor of Law at George Washington University. In addition, she's a non-resident fellow at the Stimson Center, an Air Force Reserve officer, and a board member of No One Left Behind, nonprofits overseeing the nonprofit's efforts to evacuate allies from Afghanistan. And finally, Ido Rosenzweig is a professor of counterterrorism at University of Haifa. He is director of research on terrorism, belligerency, and cyber security at the Minerva Center for the Center of Law under Extreme Conditions at the University of Haifa. And he's co-founder and chairperson of the Association for the Promotion of International Humanitarian Law, a distinguished group. Shiri, please go ahead.
Thank you very much, Marianne, for this introduction, and thank you for our phenomenal panelists today. I'm very glad that we could continue this tradition of kind of updates and discussion on what's happening on this front that, you know, is occupying a lot of people around the world, not just among us international law people. And so I think each of us will raise a few topics that we think, or a few issues that we think, you know, are important and relevant for discussion. And we can, of course, expand during Q&A further. So I think some of the other panelists will, you know, say more on the proceedings that are currently at the ICJ and the ICC. So I will not say anything kind of very detailed on that topic, but I did want to say something that I think also we kind of also raised in previous panels, and that's about the legal terms and the role of international humanitarian law and international criminal law in the context of this conflict. Because, for example, since the ICJ took kind of started, and we have reports on the ICJ genocide, on the genocide case in the ICJ, a lot of the discussion started focusing more on the question, is Israel, committing genocide in Gaza? Seeing, and I think, some considering this as well, if this is not genocide, as sort of, vindication of Israeli actions in Gaza. And I think, and the same thing happens, with criminal proceedings. So if you don't have a conviction, which is not that easy on any of those kind of type of processes, it is type of vindication. And I just wanted to say something about the limits of those legal terms and the limits of proof more broadly during armed conflict. Which I think narrows down the discussion and kind of takes away some of the very, very some of the clarity of what's absolutely wrong and is happening in front of our eyes, whether it's genocide, whether it's war crimes or crimes against humanity. And I think, however we call it, starvation of civilian population as occur currently in Gaza is absolutely wrong, no matter how, what legal term we use to characterize it. And so I just wanted to open with kind of thinking about not just, what is exactly happening right now in each of the international tribunals, but what type of discussions it kind of, drives and makes us kind of think about or consider. The other thing that I wanted to say about those legal terms is they're very limiting. We have very few kind of, grave breaches of the Geneva Conventions or international crimes that have tribunals that can adjudicate them. We don't have a crime of prolonged occupation. We don't have a specific crime of apartheid. We don't have particular, obligations around how or where or when, to reach peace agreements or peace settlements. And we don't have very clear obligations around a lot of other things that perhaps are outside that kind of limiting legal jargon, which also kind of, I think, frustrates some of the imagination of what we can do in order to break that cycle of violence and reach some sort of not just ceasefire, but an actual resolution of the conflict for a long time. And I'll just end by saying that I spent my day yesterday in the Gaza Solidarity Encampment at my university. And I think this is something that a lot of us academics are experiencing these days. A lot of, action on campus and with universities responding in a variety of different ways. Most of them are completely unacceptable. So while I do think that, freedom of speech and academic freedom on campuses is absolutely important, which is why I kind of spent the day yesterday doing a teaching at the encampment and kind of thinking about various kind of issues around the conflict and thinking, well, this is the way we should go if we want to respond properly as academics to what's happening on campuses. I do think that feelings of students right now are less important than the actual victims of the conflict. And so I do think that it's really important not to look at what's happening, in Columbia or UCLA, and then, let that kind of take attention away from, what actually needs to be happening right now. So I'll end my preliminary introductory comments here, and we can continue and perhaps go back to any of those issues later. Marianne, you're muted.
Yes, thank you, Sherry. Omar Dajani, please go ahead.
Thanks so much, Marianne. Thank you very, very much for pulling us together again for a conversation. This really is an esteemed group, and I'm honored to be a part of it. And thanks to Sherry as well for your comments and for directing our attention exactly where I think it needs to be directed at this moment, particularly as Israeli troops mass outside and begin to penetrate the city of Rafah with the extraordinary consequences that seem likely to follow from that, it's really, really urgent for us to be talking about the humanitarian law and human rights law implications of what's happening on the ground. That said, I'd like to direct our attention a little back in the weeks since the last time that we convened as a group. On April 3rd, there was an important article in the Israeli-Palestinian publication 972, which I think raised some issues that really require conversation in a forum of this kind. And there are 3 points from that article that I think it would be valuable for us to discuss and process together. Now, a little bit of background. I think most people on this call will know that one of the ongoing justifications for the scale of civilian death that has occurred in the Gaza Strip over these last 7 months has been the allegation that Hamas has been using civilians as human shields. And I think that precisely the scale of Hamas's practice on that front is something that warrants consideration and further exploration. And that's not so much the focus of the comment that I want to make. But the piece that was published by Yuval Abraham in 972 raises a related set of considerations. In the piece, it's revealed that one of the reasons why we saw such a large scale of death, civilian death, in the first weeks of the war in particular, was because Israel was using artificial intelligence to target people who were determined to be involved as Hamas militants, members of the Hamas military wing in some capacity. So using AI to target those folks, and to a very substantial extent, targeting them while they were in their homes, asleep in their beds at night. And that in the calculations of with regard to what kinds of bombs would be used to target Hamas militants, according to the article, the most precise munitions, the ones that were likely to cause least collateral damage, were reserved for very senior Hamas officials, whereas more junior ranking folks, including, as far as the article suggests, anyone from the rank and file, was targeted, if that's the right word, with 2,000-pound bombs. And the calculation that was used was that a collateral impact involving the death of 15 to 20 civilians was justified by the successful elimination of one Hamas fighter. And so what you had was an incredibly rapid assault on civilian areas during that period, during which thousands of people were caught in this conflagration. Thousands of people killed at night as Israel's artificial intelligence powered system undertook to take out these operatives. And so it raises 3 important questions to my mind. The first is, when we think of what it means to use civilians as human shields, typically the idea is that a civilian is being used in some way to insulate a military objective from military attack. What we are grappling with here is almost precisely the opposite, where the presence of a single soldier is used to transform what would otherwise be a civilian object into a military objective, even if there are 24 civilians present. And I think that that's really twisting and turning the concept of what we mean by human shields and how we deal with them in important ways. Secondly, I think that we've got to give some attention to what proportionality means in a context like this. How a calculation input into AI that 15 to 20 deaths are justified when taking out a low-level fighter. And then the third thing, and I'll end here, is really asking, in a context where precaution is so central, what it means to be leaving these decisions to artificial intelligence with apparently minimal ongoing supervision. There was a test undertaken at the outset. It was determined that the test achieved effective results, and then this machine was able to operate willy-nilly to affect the destruction that we've seen on the ground. Looking forward to the discussion. Thank you. I think you may be muted again, Mary.
Yes, I know. I will get the hang of this. How many times have I done this? Thank you, Omar. Professor Sadat.
Thank you so much. And Marianne, thank you so much for your kind introduction. And to my fellow panelists, it's wonderful to be with you, although it's with a heavy heart, because this conflict, I get these Haaretz newspaper emails to my inbox every day. And today, I believe, is day 217 of what has seemed like an interminable and really awful conflict. So I should say I'm speaking solely in my personal capacity. Nothing I say should be attributed to the International Criminal Court. Nothing I say should be attributed to anybody other than myself. What I will say is I've been watching conflicts for over 30 years. That's a pretty long time. And this conflict has really rocked, I think, the international community because, as Shiri said, law only works if it's complied with. When it's not complied with, it's really hard to make states comply with it. The other thing we know, which picks up on Omar's point, is when, I should say Omar D's point, law at the international level is a reciprocal system. So right now, somebody might be cheering for the use of AI, not realizing it could come back at them someday. And so when we think about the laws and customs of war, when we think about international law as a legal system, we understand that all states have a responsibility to comply with international law to protect the international legal order as a whole, and to protect their own citizens in case of future conflict. We've seen this over and over again. I remember when the United States invaded Iraq in 2003, I was immediately called onto CNN and various news shows because the Iraqis had taken several Americans prisoner and had paraded them on television in a way that the United States thought violated the Geneva Conventions. And there was huge uproar in the United States about the alleged mistreatment of our soldiers, whereas just a couple years earlier, we had deprived Afghan nationals of the protection of the Geneva Conventions because we thought it might be convenient in our war on terror. So there's a reason why every state in the world, including Israel, has ratified the Geneva Conventions. Most states in the world have ratified the Genocide Convention. We don't yet have a Crimes Against Humanity treaty, so we can't ratify that one, but there are 124 states that are parties to the ICC statute in which it's codified, and actually another 4 and probably 5, because Lebanon has said it will accept the jurisdiction of the ICC, that will now be under the jurisdiction of that court. So what I'd like to do very quickly is talk a little bit about that court, if that's okay, Marianne, because there's a lot of questions about the ICC.
Please.
Okay, and then a little bit about crimes against humanity, sort of veering away from IHL. So the ICC received the situation in Palestine on multiple occasions, as many of you know. And I've written a little explainer on this. It's on Jurist with links to all the various documents. So when the International Criminal Court received the ICC, a referral from Palestine, in the first few years, the argument was Palestine isn't a state. We can't do that. You have to go away. So they went to the General Assembly. They came back after they were voted their non-member observer state status, and they acceded to the Rome Statute of the International Criminal Court. And what happens when a state accepts the ICC's jurisdiction is it doesn't just mean that it can use the court as a weapon, which some have asserted. It means that it is obliging itself not to commit ICC crimes. So actually, all peace-loving states should embrace every time a state ratifies the ICC statute, it's saying, I'm not going to commit war crimes, crimes against humanity, and the crime of genocide. That's what that means. It doesn't just mean I can use the ICC as a sword or as a shield for my own people. I'm not going to commit these crimes. And so Palestine acceded to the statute. Palestine then referred the case. It was referred again. And finally, in 2019 and 2020, Prosecutor Bensouda concluded that there was a reasonable basis to believe that war crimes had been committed in the West Bank, in Gaza, in the West Bank by Israelis, in Gaza by Hamas and other armed groups, and by the IDF with respect to the conflict in 2014. Now, the conflict in 2014 was teeny tiny compared to today's conflict. It was, let's say about 1,000 in Gaza, 13 Israelis, but it was ferocious. It had lasted for some days, and the ICC concluded that it had a reasonable basis to believe that war crimes had been committed by both sides in that conflict. The ICC, as you might remember, in 2020 was sanctioned by President Trump of the United States. The prosecutor was under personal sanctions. And basically what she did then is left the dossier from the 2014 conflict to her successor. In the interim, Prosecutor Bensouda had also gone to the pretrial chambers and said, let me make sure I have jurisdiction in this case, because everybody argues about what jurisdiction is with respect to the state of Palestine. And the pretrial chamber confirmed that, yes, the ICC had jurisdiction. Now, I've heard a lot of I've heard a lot of complaining, that's a nice word, by various government officials about ICC jurisdiction over the nationals of non-states parties with respect to the situation in Palestine. I find that complaint completely spurious. Spurious. And here's why. The ICC has systematically created a jurisprudence over more than 20 years where the nationals of non-states parties are before the jurisdiction of the court if they commit crimes on the territory of ICC states parties. We've seen that in every situation, practically. The Nitaganda case involved a Rwandan national who had committed crimes in the DRC. South Korea came to the court arguing that North Korea was committing crimes on its territory. Ukraine has said the Russians are committing crimes on its territory. And the most significant proponent of the no jurisdiction over non-state party national theory has been the United States of America, with Israel behind. And the U.S. has conceded jurisdiction in the Ukraine situation. So the non-state party national, and I have like a huge article in the Notre Dame Law Review on this, I think that's a non-starter. States can protect their territory by ratifying the statute. Now, some have argued Palestine's not really a state. For ICC purposes, it's a state. It's acceded to the statute. The General Assembly has voted it. The Secretary General has accepted its instrument of accession. And so that's that. In the current conflict, so what crimes could we see? Now, the ICC never issued arrest warrants or summonses in the 2014 conflict. I think that was a huge mistake. I know that the prosecutor was under sanction. I know that Karim had a big dossier when he came into office. But what we've seen is that immunity leads to impunity. When we don't talk or tackle the small situations, they grow out of control. And now we are in a conflict that has spiraled completely out of control, where we see all three ICC crimes clearly on the table. We don't just see war crimes on both sides, we see crimes against humanity, and now we have significant allegations of the crime of genocide. And with respect to those allegations for crimes against humanity, and I'll just say what the crimes are and then we can talk about it, a crime against humanity, unlike a war crime, can exist during peacetime or armed conflict. So in fact, we do have a crime of apartheid. It is a crime that can exist in peacetime. I'm not saying whether or not it's been proven. As Shiri has said, the threshold is high. The bar is very high for proof of crimes at the ICC. You have to show intent to commit the crime, that the elements of the crime are there, and you have to prove all that beyond a reasonable doubt in front of very skeptical judges and very effective and active defense lawyers. I say that as somebody who worked for the prosecutor for a long time. So it's not easy to win a case at the ICC, but I think we have a reasonable basis at this point to believe that all three crimes now are sitting in the ICC. A crime against humanity is a widespread or systematic attack against a civilian population pursuant to a plan or policy. Whether or not you think the current actions of the Israeli governments are genocidal, they certainly have a plan, right? They certainly have a plan of starvation of civilians. They've articulated it at multiple ends. They've said it many, many times. And so we have a plan or policy. We have a widespread or systematic attack. And remember, for crimes against humanity, the attack doesn't even have to be a military attack. It just has to be a course of conduct that includes the crimes against humanity in the statute. And those crimes are murder, enslavement, deportation, extermination, torture, arbitrary arrest and detention, which is a big one we're looking at in the West Bank, other inhumane acts, the crime of persecution based on a wide variety of groups, and many, many other ICC crimes. So,
Professor Sadat,
yeah,
I'm gonna,
yeah, I'm sorry.
No. That was extremely helpful, and you gave a very clear presentation. I would like to invite you to send me in the chat, if you would, the links to your article in Notre Dame Law Review and your piece on Juris, and I'm going to post them in the Q&A. If anybody else, and perhaps Omar would also send a link to the article he referenced. And we'll come back to you. Thank you so much. That was terrific. Our next speaker is Omar Shakir, who serves as the Israel and Palestine Director at Human Rights Watch, where he investigates human rights abuses in Israel, the West Bank, and Gaza. And he has authored several major reports, including a 2021 report comprehensively documenting how Israeli authorities have committed the crimes against humanity, which we've just heard an explanation and definition of apartheid and persecution against the Palestinians. Omar, please go ahead.
Thank you, Marianne. And again, my thanks to you and to the DC Bar and ASIL, the Labor Society, for organizing. An honor to be with such an esteemed panel. I'll keep my introductory remarks brief. I think 7+ months into the hostilities between Israeli forces and Palestinian armed groups, we're seeing a confluence of several trends that I offer the way this is resolved in the days, weeks, and hopefully not, but months ahead may well portend the future of the rules-based international order. The first is the abuses of international humanitarian law and human rights that are of a scale unprecedented in the modern history of Israel-Palestine. We have discussed the content of those abuses in previous sessions, and I have no doubt we will discuss them. The second is the unique nature of the proceedings at the institution charged with defending these principles at the International Criminal Court, at the International Court of Justice, but also the negotiations and discussions that are happening in quarters of the United States, the UK, Canada, Australia, the EU, many other countries where they're charged with determining whether or not to issue sanctions, whether to provide arms, all based on their own analyses of international humanitarian law. So you have these phenomena happening together. And the third, development that's happening in unison is that this is all happening, a couple of years after the Western world in particular rallied around the importance of international law, the International Criminal Court, accountability, the law of occupation, and really putting money to mouth to defend the international rules-based order. And now you have a different part of the world. You have the global South. You have countries like South Africa Africa, and others that are going to these same bodies and seeking to hold countries in the global north to the very same standards. Since I last joined, I think I missed the last one or two of these sessions. We've seen several developments in that realm that are quite significant. The first, of course, is the issuing of provisional measures by the International Court of Justice. Human Rights Watch has documented how the Israeli government is not complying with these provisional measures, in particular, the measures around ensuring the provision of humanitarian aid and basic services. There was the initial order in January. There was a follow-up order in March. We've published multiple reports now documenting how not enough aid is getting in, how the Israeli government is using starvation of civilians as a weapon of war, how the aid is not being allowed to be distributed within the Gaza Strip, and how key items continue to be withheld. Now, why this is so important is, regardless of what you think about the genocide claim, or even about the court's issuance of provisional measures, which, by the way, were enacted nearly unanimously, 15-2, 16-1 on certain measures. I think the world all agrees on the importance of the role of the International Court of Justice. And if its measures are simply ignored, that undermines not only the protection of civilians in Israel-Palestine, but it undermines the very court charged with defending this rules-based international order and civilian protection around the world. So I posit that the lack of compliance by the Israeli government and the failure of Israel's allies to ensure its compliance, to use all of its leverage, including an arms embargo and targeted sanctions, to ensure that Israel complies with the International Court of Justice, really threatens to undermine the very viability of this court. And similarly, and Professor Sadat noted this, the International Criminal Court. We see unprecedented threats being made around the prosecutor, around the International Criminal Court. This has been reported on in recent days. These measures, again, risk undermining the ability of the prosecutor to follow the evidence wherever it leads and to make the indictments that are necessary. This is about the independence of the prosecutor and the degree to which states intervene in this process. Again, that undermines not only victims in Israel-Palestine who faced a wall of impunity in country for serious abuses committed, but it affects the very credibility and the very independence of the court and its prosecutor. So I'll wrap up here by just saying this, how we deal with these tensions. This is, that's a huge question for the future of international law. And there's no more important question for ASIL, for the DC Bar to be considering with than how do we ensure these principles and the institutions charged with defending it, that their independence is respected and their ability to follow the evidence in the ICC case and the ICJ case, the ability for their orders to have effect remain in place. Thank you.
Thank you very much, Omar. Lauren.
Great. Thanks again, Marianne, for putting this together. Happy to be back with everyone. I want to, first I'll say also that this is in my personal capacity. Nothing I say represents the United States Air Force. I wanted to talk a little bit about humanitarian notification and deconfliction. Right now, 1.7 million Palestinians are considered displaced, which is about 70% of the population. Famine is imminent, right? 1.1 million are suffering from catastrophic food insecurity. So a large problem ongoing. And then with the operations in Rafah, that is where many people fled. The population there is 7 times what it normally is. But also that's one of the main aid corridors into Gaza. So this problem is likely to get worse. There's obviously the April 1st airstrikes on the World Central Kitchen convoy, humanitarian convoy. But also, since the conflict began, 224 humanitarian aid workers have been killed, according to the United Nations. That's 3 times as many in 1 year than any other conflict. This has happened from both sides. It's not just, the IDF that has accidentally killed some aid workers. There's been a number of aid workers killed. But just a huge scope of a problem. Obviously, there's a debate on whether or not this is an IAC or an IAC, depending on who you talk to. But as a matter of policy, Israel applies IAC principles. So, looking at that in this context, you have
Lauren, IAC, International Armed Conflict, NIAC, Non-International Armed Conflict.
Thank you. So there is a question on whether or not Palestine is a state. If Palestine is a state, this is an international armed conflict. If they're not, this is a non-international armed conflict. So different legal obligations would apply. But because Israel applies the international standards as a matter of policy, I was just going to focus on those. So you have the additional Protocol 1, Article 70, specifically Section 2, which talks about, all parties shall allow and facilitate rapid and unimpeded passage of humanitarian aid. Customary international law says the exact same thing. There's also the question of occupation, right? And so at the point this is an occupation of Gaza, there's an obligation not just to facilitate that aid, but actually a duty of ensuring the population has the appropriate aid, right? So that you actually have to bring in the aid. So a much, much higher standard if this is indeed an occupation. And then specific to the case of Israel, Gaza, and what's happening now, you've had a number of UN Security Council resolutions, the most recent of 2728, which reiterated its demand for the lifting of all barriers to the provision of humanitarian aid. But I want to focus on that protect and facilitate piece that I talked about, because this is done through humanitarian notification and deconfliction. UN OCHA has an unwieldy name for it. They call it Humanitarian Notification Systems for Deconfliction, HNS-4D. If people are interested in that phrase, but it's an incredibly complex process to actually protect and facilitate aid in practice. Requires the collection of protected entities, both the humanitarian aid organizations providing that information, but there's also an obligation on the state parties themselves to collect and know what those protected entities are. And that can be anything from hospitals and static facilities to actual movement of aid convoys, medical supplies, just people moving through. And so that deconfliction can be both, static sites or dynamic. So a lot of information that has to be collected, the processing of that information, then the dissemination of that information to the right military entities. So who needs it and how frequently do they need that information? And then the operational deconfliction prior to engagement, actually having a process and checking to ensure that whatever you are engaging has not been listed on one of those deconfliction locations. And then emergency deconfliction, which is, once something is being engaged or there's effects on a humanitarian entity, the ability to communicate with the military. So the IDF put out specific conclusions from their investigation into the April 1 airstrikes. They did note that the World Central Kitchen did provide information on what they were doing and where they were going, but they did go slightly off route. I will, say that does not make it a valid target, right? But it can harm identification if it wasn't necessarily on the road or at the time it was supposed to be. So that can make identification harder. It's also really unclear from the dissemination purpose that Southern Command, who was in charge of this strike, actually got the information to know that this aid convoy was traveling at that time. So that seems like a breakdown either in process of them being on the right list or them getting the updated information. And it looks like there was no operational deconfliction, once again, speculation, but the fact that before they struck, they didn't check up the chain to see if there was some kind of convoy going through the area. It looks like this identification was based off of, according to the IDF, the identification of two gunmen. They saw two people with guns and associated them with Hamas and then assumed the entire convoy was Hamas. On the emergency deconfliction point, in a case like MSF, where the U.S. accidentally engaged the MSF hospital in Kunduz, the strike occurred for over 30 minutes. According to the U.S., MSF says it was an hour, but at least 30 minutes. And so there was a process in which they could call the military and try to get the operations to stop. A lot of things went wrong there and they were not stopped. In this situation, on April 1st, the entire strikes happened over like a 5-minute period of time. So fast, there just wasn't actually the ability to call in and stop anything in that case. But when you hear about this whole scenario, I think, there's two takeaways. One is that it looks like there was significant failures in the process. So there's a lot of room for improvement. And then two, just looking at the scale of the humanitarian crisis in Gaza and the potential for that to increase in Rafah operations ongoing now. It's just the need to really focus on this and look for more assistance from international organizations and others to really make this process one that works, or we're going to see this famine hit and we're going to see the problem get much worse. Thanks.
Thank you very much, Lauren. And now, Ido, adding cleanup.
Thank you. Thank you, Marianne, and the organizer, ASIL, and Libre Society, and the DC Bar, And also thank you to the people in the background, Taylor and James, for organizing everything. I think so far, this has been one of the only consistent webinar series that has managed to maintain an open and interesting discussion, despite several, and even I would dare to say significant disagreements that we sometimes have among the speakers. And that alone is an amazing achievement in this time and age that we experience. In my opening words, I would like to focus on a point that in previous sessions I actually concluded with, and that is the differences between what we have and what we can manage versus the things we wish them to be. And I'll clarify. We all in this panel have problems with the damage caused in the Gaza Strip, damage to the civilian infrastructure and to civilians. And we all wish that the warfare would have been shorter and without such damage. There's no doubt, I think all of us agree on that point, but that doesn't mean that we can draw the conclusions that violations have taken place just because we are unsatisfied with the outcomes. We can't go into allegations of genocide, crimes against humanity, and war crimes if we don't have sufficient information to support that. And I've read all or most of the reports that have been published on the situation in the Gaza Strip and in Israel operations towards the Gaza Strip. And I do have serious doubts that most of the violations of war crimes, crimes against humanity, and of course genocide, have been substantially supported by the evidence that we've seen and read. And for that matter, for example, the ICJ's decision on the South Africa versus Israel on the genocide case did not conclude that there is a genocide going on in Gaza, nor that it even plausible that there is a genocide going on in Gaza. Yet we've seen how the narrative about the decision and about the provisional measures that the court has ordered has been shifted into a discussion of allegations of genocide that are already going on, and whether or not Israel is indeed committing genocide in the Gaza Strip. And that discussion is one thing, but connecting the ICJ decision to that discussion and base your discussion on the provisional measures that have been issued, that's a bit of changing and trying to do a shifting of narrative of the decision to the discussion. And I will support what Shiri said at the beginning. Freedom of expression and academic freedom are at the highest value. And if someone wants to advocate that there is genocide going on, definitely they're allowed to do it and they should do it. But don't base it on the ICJ decision that did not say anything of that sort, just gave provisional measures. And we can talk later on about how, and I think we've talked in previous session also about how they reduced the standard of issuing provisional measures for that matter, and that would be dangerous for the court later on. At the same time, there is almost complete silence on the refusal of Egypt to allow Gazans, refugees, to go into Gaza and go away from the hostilities in southern Gaza, in the Rafah area, and go and cross the border into Egypt territory in order to be safe from the attacks, from the situation, and receive better humanitarian care. And on that note, I would actually mention the special rapporteur on torture that has recently published a paper, an article on that specific issue. Now, I'm not saying that that was the only thing she argued. She argued that Israel's actions might be acts of torture toward the Palestinian population. But at the same time, she also said that the Egyptian refusal to allow Gazans to go into Egypt might be in contrast with their obligation under the Genocide Convention if we go into the discussion whether or not there is responsibility. I would argue that someone should ask Egypt through the ICJ, through provisional measures, to allow Gazans to go into Egypt to seek refuge. Now, that's being said on the ICJ and that context. When we talk about IHL balances between military necessity and humanitarian concerns. It has several limitations on the means and methods of warfare, on the definition of military target, and on the damage that the military is allowed to cause to the civilian population in contrast to military advantage, i.e. proportionality. But we cannot overemphasize only one side of the scale. We cannot only put our focus on the humanitarian aspect of international humanitarian law. We need to also address the military necessity of it. If we ignore the military necessity aspect of IHL, we harm the balance, the delicate balance within IHL between military necessity and humanitarian considerations, the limitations and the military necessity on both sides. And the outcome would only harm international humanitarian law, would only end up causing more damage on the battlefield. And as my professor of constitutional law, actually, in Northwestern back in the days, used to say, be careful what you wish for. It could lead to very dangerous output. Now, IHL is not perfect. Warfare is not perfect, but there are always two sides to the conflict. And even if the IDF would have done everything perfectly, and I don't argue that the IDF does everything perfectly. I think there are faults, there are mistakes, and I'm sure that, and I actually I'm very active on calling the IDF to investigate and inquire mistakes and violations as they might take place. But even if the IDF would have operated perfectly, the damage to the civilian population in Gaza would still be significant. And that's because the modus operandi of Hamas, including the use of human shields, which Omer Dajani made a slight reference to, but also using treacherous methods of warfare and attacking humanitarian convoys, as we've seen a few days ago, attacking Kerem Shalom crossroad, which caused the IDF to block that area for a couple of days for security reasons, and which meant less humanitarian aid was able to go into the Gaza Strip. Now, the military operation against Hamas was not an act of aggression by the IDF. And Leila, I think in your list of violations, you forgot act of aggression as part of the ICC. I mean, not necessarily has taken place in this conflict, but we have 4 types of crimes in the Rome Statute. We also have the crime of aggression. The IDF and Israel response on October towards the Gaza, towards Hamas, was in response to the horrific attack of October 7th. The legitimation of the use of force with regard to the response to the attack on October 7th does not justify and cannot justify and will never justify violations of international law. But it does clarify that apart from the calling for a ceasefire of the region, which I'm not against, of course, we ought to make sure that such a ceasefire will also take into account the requirements, the necessities, and the safety of the Israeli side in that region. And that means, first and foremost, the immediate and unconditional release of the hostages. Bearing in mind that keeping those hostages is an ongoing war crime, keeping them incommunicado is a crime against humanity of enforced disappearance. And saying that the release is pending to any mutual release by the Israeli side of Palestinian prisoners and detainees could be seen, not necessarily has to be seen, but could be seen as supporting the crimes of holding them. I'm not saying that it won't end up with a deal of releasing from both sides. We've seen that before, we will see that again. But I'm just saying this should not be the first preferences. We should call very actively for the immediate and unconditional release of all the hostages and without any conditions added to that. And secondly, and it means that the safety, the implication towards Israel and calling for the ceasefire, we have to take into account the safety of the Israeli residents in the south of Israel, and it must be maintained. They need to be able to go back to their home. They need to be safe within their own territory, and they must not fear for another immediate return of October 7th events. Now, otherwise, it's just a matter of time until we have that cycle coming back on, and this would be bad for everyone, the civilians for the Israeli side and the civilian on the Palestinian side, and we don't want that to happen. And I will finish with one sentence that when I read a lot of the writing and I hear a lot of the panels on that discussion, and again, usually I put this panel aside from what I'm about to say because of the unique nature of this series of events. But it seems that this discussion among our colleagues, among scholars, and generally in the media, that there is the approach to this conflict has become very similar of sports fans to their teams. I mean, people pick side and they reject and object any other claim which is not in favor of their team or not against the other team. And things are not binary in this conflict. Things are not binary in this region or in the Israeli-Palestinian situation. And we ought to be able to discuss those challenges and resolve them in a manner that would be beneficial for both sides, for both peoples, and not only see things from one perspective, and that's it. Thank you.
Thank you, Ido. Thank you all for, you've covered a real range of the IHL issues implicated by this conflict. I wanted to start us off with, we have posted in the chat links to useful articles, including those of the one referred to by Professor Dajani and an article authored by Professor Sadat. If you have a question, please put it in the Q&A, and we do have a question, and I'm going to play off of it. It's a question about proportionality. References have been made to the core principles of IHL, international humanitarian law, such as military necessity and proportionality. What are the implications for international humanitarian law? Which core principles are at play in the Israel's planned military operations in Rafah, which of course have been in the US press because of Biden's response, the Biden administration's response to them? The question we have in the Q&A, by the way, is a question about the term proportionality and where it is used in the Geneva Conventions and what exactly definitional.
So I think Omar Dajani already answered that in the Q&A. I was about to send the link to the first protocol, so thanks, Omar. So I think we have there the specific answer. I think the topic of proportionality is a good one because it touches on a lot of the things that some of the panel members already touched upon, and especially perhaps Omar Dajani, when you kind of mentioned the IDF AI scheme, because I think and this is an issue of concern more broadly because the IDF is not going to be the only military to be using or relying on AI systems for lots of purposes, including identification of target, but also, calculation of collateral damage, for example. I mean, the US military uses algorithms, not necessarily AI based, but as years go by, we have those systems of collateral damage estimation are becoming more and more sophisticated. And I think this changes how we think about proportionality in more ways than one, because it means that different types of not just algorithms, but also facial identifications and kind of drone visualizations and sensors are determining for us not only whether humans, exist in a particular area, but also whether those are male or female, old or young, and what are their characteristics, right? And that requires that we feed or teach those algorithms. How do we imagine bodies of children or men or women look like? And it also, forces us to make all sorts of assumptions in those kind of training data sets and in our kind of design of the algorithms that completely changes how we think about protection. And personally, I find this is one of the most alarming areas of concern right now. And we see the implications of that, not only, by, the Israeli military in Gaza, but we can see the impact of AI and drone systems, in the US war in Afghanistan with various case studies that I've published on. And I think the case that Lauren mentioned about the attack on the aid convoy is also an example, because you mentioned that they witnessed, for example, gunmen on those vehicles, but in fact, and I haven't seen the drone visuals, but according to reporters that have been, in the press conference where they were shown those videos, and according to the reports of the IDF itself, actually one of those people identified as being a gunman were not at all, holding guns. Actually, they were holding a bag, but it looked like a gun, or it looked like some sort of weapon. And we've seen that, in previous cases with the IDF, where, men holding firewood, were actually identified by, a drone team as holding RPG rockets. And so problems like that are going to increase in the sense that, while we all have, issues of vision and how we see things in the battlefield, where we see or witness the battlefield through the lens of a drone, that of course changes how we think about what happens on the battlefield and how we think about protection. I see that Leila also has something to say here, so please.
I thought, Sherry, you gave such a great example there. And what I was thinking was and as I said, I've been looking at conflicts for a long time. So I'm thinking of the NATO bombing of Belgrade, which went on for about 3 months. And I've written about this a little bit in my explainer. And there were accusations that NATO was engaging in indiscriminate attacks, right? Indiscriminate bombing, because their aircraft were flying so high that the argument was they couldn't accurately assess the targets that they were hitting. And ultimately, basically a commission of inquiry, a committee that was convened to assess whether or not NATO had engaged in war crimes during that particular bombing campaign, which was a long campaign. It's over 10,000 strikes, et cetera. They did find 6 incidents in which they found that NATO had made mistakes. But because the overall casualty level was somewhere between 250 and 500 civilians, they concluded there was not a pattern or practice to commit war crimes, and they concluded that the ICTY, which was active in the field, did not have to investigate. That is, that there were not going to be NATO war crimes. Now, if we think about that, that sounds like the good old days, doesn't it? Right? 250 to 500 casualties gave rise to a commission of inquiry, serious allegations of war crimes, and it was NATO's flying over 15,000 feet that was at issue. And ultimately, they decided that wasn't a per se offense, but it did raise significant questions. Now we're talking, even the example you gave, Lauren, about how the whole World Central Kitchen attack takes place in less than 5 minutes, as opposed to even the Kunduz hospital attack, which took place over an hour. It's happening so fast and so furious that there's literally no capacity for humans to intervene and say, stop. And I think that's a serious problem, not just in this conflict. It should terrify all of us who believe in peace as a fundamental human right, because once war starts, if it's happening this fast and this furious, we're looking at casualties now in the tens of thousands and arguing about proportionality when we were looking at 250 to 500 in 1999 and 2000 and saying that's a really high level of casualties. So I think we just have to realize that this is spinning wildly out of control and kind of rein in our own expectations of what is reasonable in a particular conflict to be able to absorb, and to make sure that human beings actually, and I've criticized the Obama administration for the drone strike campaign, so I'm not picking on any particular state. I think there has to be human intervention, and it has to be slow enough that people can actually assess whether or not a target is legitimate or not, or in my view, it's disproportionate practically per se, because it's indiscriminate bombing.
Thank you very much, Leila. It raises the question of command responsibility, which we can come back to. Ido.
Thank you. There are 2 points within what we've heard that I want to address. One is AI. Now, AI, as any technology, and any technology whatsoever, is user sensitive. It can be used for bad, it can be used for good. I mean, the mere example that Shiri gave, that seeing someone with a stick might be mistaken for a weapon, one could argue that a good AI system, if it has good enough standards, could actually make that identification and save and deny the attack instead of confirming it because of a human error that thought that, well, that stick was indeed a weapon. It's very, very user sensitive, and we don't need to be afraid of AI categorically. We just need to make sure that it's being used properly. There are different ways to address it, and I have a draft paper together with Dr. Magdalena Pacholska that we're talking about, facial recognition systems and targeted killings. And one of the things that we say there is that at this point, the technology is not better than the human eye. It's not better. It doesn't meet the standards of the human ability in field situation. And therefore, a human should always overlook what are we doing, but it definitely could be used as a tool to help us in that situation, to identify civilians, to identify combatants or fighters in the field. So the use of technology is very user sensitive, and we need to be cautious about it, but we don't need to categorically ignore that. Now, on the issue of proportionality, there are 2 things that come in mind. One, just to complete what Omer Dajani wrote in the Q&A, when we look at proportionality, we look at a test that has 2 sides. We have expected military advantage and anticipated collateral damage, and we need to compare them as long as the anticipated collateral damage is not excessive towards the expected military advantage. We're good to go. There is no question of disproportionality, and the attack is allowed on proportionality aspects. And that means that we need to know what was the military advantage, the anticipated military advantage from the operation, in order to have a final decision if that operation was indeed proportionate or disproportionate. And on the other hand, we cannot look at the big numbers and talk about proportionality. We cannot look at the entire conflict and say, well, that amount of combatants or fighters of Hamas have died, and that amount of civilians have died in the complete warfare that we have had so far, we have to look at proportionality on a case-by-case scenario, each military attack, because each military attack has its own proportionality test, and we cannot look at the big numbers of the entire warfare. So I will end here.
Thank you very much, Ido. Just a quick point on your facial recognition point. Recent research and ongoing research has indicated that it's particularly inaccurate along racial lines and along gender lines, and that poses a lot of problems. Omar.
Thanks very much. There were three things I was hoping that I could speak to a great extent in relation to the issues Ido has raised, but also in an attempt to come back to the situation in Rafah. So the first thing that I just want to highlight is that those of us who work in the arena of IHL need to really give some thought to what is encompassed in a proportionality analysis. There is I think, really important study, which I think I alluded to last time, but which I want to highlight again, that Mara Revkin and Janina Dill, among others, have initiated to look at the concept of cumulative civilian harm. And the key idea there is that when we are examining proportionality, that it is a mistake for us to focus narrowly on the consequences of a particular attack for civilians, particularly in circumstances where the harm suffered by civilians is compounded not only over the course of a single armed conflict, but in some cases over the course of years of successive armed conflicts, and the challenge posed by occupation in the Gaza Strip of rebuilding after those armed conflicts. So I think the law is less developed than one would hope on this area, but I think that the analysis that Ido is urging us to make points, to my mind, to a real deficiency in our approach to dealing with these issues under IHL. If our aim, as it should be, I think, is to ensure protection of civilians in the context of military operations. Second thing I wanted to note is that when we turn back to the situation in Rafah, what we have to bear in mind is that, again, we've got something around 1 million people sheltering in that space, many times more, as was alluded to earlier, than would normally be present there. And so the consequences of military operations in Rafah are likely to be enormous. And that leads us to a question of what exactly the military objectives are in that context. And to be sure, it is not going to be possible for us, to Ido's point, to fully assess that at this juncture. But it is absolutely an appropriate role for us to be pushing and asking, what exactly are you aiming to achieve? And it seems to me that the aims that get articulated are elimination of Hamas as a military actor in that space. And I think that if we look at the last 7 months and the extent to which that objective has been achieved, even in places like northern Gaza, where the attack that Ido pointed to earlier occurred, it seems very, very implausible that even a ground operation in Rafah would achieve that objective. But I think it is incumbent upon us to start asking the question of how pursuit of this military objective could possibly justify the scale of human consequences likely to flow from it. And here I want to make a last point. Ido referred earlier to the need for the Israeli communities surrounding the Gaza Strip to be safe, and framed that as one of the objectives that Israel appears to be pursuing in this context. And the thing is that the safety of those communities does not rest on the objective of eliminating Hamas. The safety of those communities will be achieved through the achievement of an end of occupation and a broader peace deal. But even putting aside that point, I think that we can't lose sight of the fact that the Palestinian people in the Gaza Strip also have the right to live in safety, also have the right to live free from foreign domination, in freedom and dignity, and also have the right to self-defense and to resistance against foreign domination. And so when we are working through the question of what we should bear in mind when a ceasefire is contemplated, I think that we can't forget that the right of self-defense runs in both directions, and the right to live in peace runs in both directions.
Thank you very much, Omar.
Excuse me, Marianne, sorry, I just, if it's okay to barge in, just because I had a comment on exactly what Omar just said, and I'll be very, very brief. I just wanted to kind of touch on that because I thought actually I'm going to end with that point, but because you already said that, I thought I'll just mention it as well, because we tend to think about, okay, so there is a right to self-defense because there was some violence, but violence is not the only recourse, right? So when we talk about safety of Israelis, I highly doubt that whatever is currently happening in Gaza would bring the citizens of Israel any security, and more likely it will bring less security, more insecurity for the long run, for Israelis and Palestinians alike. And I think, because this is, an IHL, ICL sort of discussion, then, self-defense, obviously is a big, part of it. But it's not, the law of life that we have to resort, go to violence. And I think in situations as complex, it's not really just about thinking, okay, what is the permissible, kind of what is proportionate, in allowing a scale of violence. The scale of violence is not necessarily justified anyways in this whole scenario. And so I just wanted to, to say that, because I thought it just, touches exactly on what you say, Omar. And I think, it has to be said, like, it's unjustified, not because Israel doesn't have a right of self-defense, but because it does no good and it does so much bad. So Lauren, sorry.
Thank you, Sherry. And we have Lauren and Omar talking about this topic, and we do have a question in the chat I want to get to before we get to wrap up. So I'm going to ask Lauren and Omar to try to keep the comments brief. Lauren.
Yeah, I'll try to be quick here. Just on the point of proportionality, as Ido, accurately described it, I just wanted to focus on one piece of it, which was the weighing of the collateral damage versus military advantage, but the phrase excessive, right? And this has been a huge debate in military communities on what does that mean? How do you determine what that is? And so as of now, no military publicly shares how they do their proportionality analysis, how they weigh the military advantage against the civilian casualties or civilian damage. And how they determine what that looks like, right? Like that's not a standard mathematical equation you can do to say 2 is, equivalent to 4 or such. And so what you end up happening in a lot of cases is it's hard to prove, right? That was actually excessive or not. Because as Ido said, you have to understand the military advantage that was expected. You have to understand what they thought the collateral was going to be, but then how those things are weighed. And then just, while the US and NATO uses the collateral damage estimation methodology, if anyone wants to look it up, you can see an older version online, CJCSI 3160.01. But that is direct harm. And we're having an interesting conversation here about what proportionality might actually be. Another argument is just the foreseeable but indirect harm, right? If you're cutting off, say, access to, items needed for survival, whether that be food, medical supplies, whatever else it might be, that those should also be included in the proportionality analysis, since that's not currently included in how collateral damage estimation methodology works. But it's something that in cases like this, where there's large scale combat operations going on, those effects are widespread, right? And so that's something that people do want to consider and think about. Specifically to distinction, and we were talking about identification, sensors really matter, right? So we talked about the specific April 1st case. So there were some reports that they used IR sensors. So, right, think of that like a heat sensor, right? You can't see quite as clear what is going on. We're talking about, the US, though, has had issues where we have accidentally identified, photographers with large camera lenses as having guns, right? And so this happens quite a few times. And to the point of AI, that can, as Ido said, actually help in some cases. I think it depends on how you're using it. We used to say, there was the concepts of human in the loop or human on the loop, right? So human's the one either making the decision or approving the decision. We now have moved more to a phrase of reasonable human control, which to me is quite vague and hard to understand what that means in practice. So I think the concern is valid, right? There is a concern that you could have AI identifying and engaging targets in such a way that it's unclear that you would meet the IHL standard of a reasonable and good faith decision, right? That your identification and your proportionality is correct. But on the other hand, there are ways that you could look at AI to do things like potentially identify civilians or indication of civilian objects or civilian presence in an area. And so there are benefits to potentially using AI. It's just not clear in this case. I'll stop there because I know we're short on time.
Thank you. Omar. Shakir.
Yes, just a couple of quick points to add. I mean, I think this discussion about AI and proportionality is important, but I think, and Lauren mentioned this, the first step is for there to be distinction. Human Rights Watch released a report last month. We did a deep dive on one of the thousands of Israeli airstrikes that was targeting a 6-story building that was housing a couple hundred people, displaced people, and we found that we counted 106 civilians killed, including 54 kids, most of whom were playing football. There was displaced people charging phones in a grocery store. And the reason I want to bring up this particular, we found there was no military target in vicinity. We looked through everything the Israeli army had said. We wrote to the Israeli government. We interviewed 13 eyewitnesses, victims on the ground. No evidence of a military target in sight. The reason why it's really important to emphasize this is to say that because of the restrictions on journalists entering Gaza, human rights investigators, the ICC, the ICJ, this kind of detailed IHL analysis is very, very difficult. So we're operating in a fog of war. We did this deep dive to provide our standard of evidence for one particular airstrike. But most of the time that a lot of time we find a problem of indiscriminate airstrikes because, and that's an issue we have here. Another phenomenon we've been documenting, I'll be very quick. Already, I think Lauren mentioned killings of aid workers. It's not just World Central Kitchen. We've documented 8 incidents. We'll be releasing a report on this next week. This shows that these aren't just mere mistakes. Also, there's been documentation of Israel using the buffer zone and treating other parts of Gaza as free fire zones. In effect, we've seen that with even Israeli hostages who had escaped and they should be unconditionally immediately released. They should have never been there, but they were killed by Israeli forces. So I think it's important we add to this debate about AI and targeting proportionality that a lot of the large issues we have to do with distinction, treating areas as free fire zones, maybe even deliberate attacks on civilian infrastructure, and the inability, because of limited access, for human rights investigators to do the kind of due diligence to really find out what's happening. We're all operating in a fog of war, deliberately set by the Israeli government.
Well, to try to comment on ongoing military operations is always extremely challenging, no question about it, much less to evaluate them under IHL principles. Our question is from Alexander Belinsky. What are obligations, and I hope I haven't butchered your name, what are obligations under international law, if any, with respect to accepting refugees from the zone of war, military conflicts, as it applies in the Israel-Gaza conflict? So what are the IHL what kind of obligations are laid out under IHL for the acceptance of refugees? Would someone, preferably one person, like to take that on?
I'm not going to take on the IHL issues, but what I would say is the reason Egypt doesn't want to accept refugees is it doesn't want to be complicit in ethnic cleansing, because it's pretty clear that if the refugees leave, they won't be allowed back. Or at least that seems to be the concern. And many of the neighboring states feel the same way. So I thought it was interesting that Ido put it in the sense of, would Egypt be complicit in genocide in refusing? That would admit that there is a genocide, right? But I think Egypt's concern, as stated, and this is widely available in the press, is that it doesn't want to create a situation in which Gaza is ethnically cleansed. The state really that could accept the refugees is Israel, right? Israel is the neighbor. They could pass into Israel. There are Palestinians in the West Bank. There's no reason that civilians could not live in Israel. So I think all states in the region obviously have humanitarian obligations under the Refugee Convention, but not to accept in large neighbors. If there's a well-founded fear of persecution, there could be asylum applications. I don't think there's an IHL obligation. Whether there should be is another issue. But I think the politics on the ground is that what everybody is hoping for is actually a negotiated solution. I think we hoped it would happen in December. I'm shocked to find myself in May with bombs still falling and no end in sight. I completely agree with Ido, by the way, that the hostages should be released. I think they should have been released ages ago. That said, it's still not, one set of wrongs can't justify another set of wrongs. And this is
Right.
why if I could just add one thing, the diplomats have a different job than the lawyers. The lawyers, we say, this is legal, this is not legal, this is justiciable, this is not justiciable, and it's not always terribly satisfying. The diplomats who are sitting in charge of this conflict really are trying to get the bombing to stop, the ceasefire to happen, and the hostages to be released. It's very complicated for the diplomats. I think it's a bit easier for the lawyers, but it's frustrating.
Thank you very much, Leila. Okay, I'm gonna give everybody a concluding remark, which is gonna have to be like 54 seconds. I'll be timing you, and I'm gonna start with Shiri.
I wave.
Okay,
I give
all
mine
right.
to Leila.
Okay, Omar Dajani.
So a quick word on the last point. One thing that we shouldn't forget is that under the terms of repeated agreements between Israel and the Palestinians, the West Bank and the Gaza Strip are a single territorial unit, the status and integrity of which is supposed to be preserved. And so one very natural place for Palestinians in the Gaza Strip to be given shelter pending the reconstruction that's going to be necessary and which will take a long time is the West Bank. I think one of the things we really should be focused on is ensuring that the political, the economic, and the social links between the West Bank and Gaza Strip can be reestablished. That is crucial to the task of rebuilding it. But I will just say in conclusion that I want to come back to the recognition that or stress, add my voice to the point that Omar Shakir made just a few minutes ago, which is that there is a limited amount of what we can know for sure at this juncture, whether we are undertaking analysis of genocide or of war crimes. But there are a lot of reasons for us to be enormously concerned, and the lack of definitive evidence should never be, in a moment like this, a reason for us to say, well, we'll just defer concern. I think that we have to really, really press hard for an end to this war, so that we can begin the process of figuring out exactly what happened and how we can avoid it the next time around.
Thank you, Omar. Leila.
What I would say in conclusion is that the war has gone on for way too long. I completely agree with Ido that we don't have Team A and Team B here. We are all on Team Humanity. The degradation of the international rule of law through the Gaza conflict, through the Ukraine conflict, through what's happening in Sudan right now should terrify all of us. And I think for democratic states like the United States that I'm lucky enough to live in, for Israel, which wants to be part of this community of nations, right? We need to uphold the values that are enshrined in the founding documents of the United Nations, not shred them. We need to uphold the International Criminal Court statute, not attack the court's officers. We need to comply with orders of the International Court of Justice, even when we don't like them, because it is in our long-term self-interest to do so.
Thank you very much, Leila. Omar Shakir.
Palestinians in Gaza, like all under the law, have a right to remain in dignity in their homes. They have a right to leave to seek safety, and they have a right to return to their homes. That includes their homes in northern Gaza. It also means for the majority of Gaza's population that are refugees that were expelled or forced to flee their homes in 1948, a right to return to their homes. So it's important to understand the full panoply of rights. Yes, they have a right to seek asylum. They have a right to seek flee for safety, whether in Israel, whether in Egypt, but that must be accompanied with the right to return to their homes as soon as the hostilities end. Israel has a long history of disregarding that right.
Thank you, Omar. Lauren.
I want to touch on Rafah real quickly, which is and the US's relationship with that. So on Wednesday night, President Biden announced that if the IDF went into population centers in Rafah, the US would not supply weapons that were historically used to deal with those types of military operations. They've held one shipment of JDAMs, so bombs, guided bombs so far. They're still allowing it through defensive weapons, things that would support Iron Dome, those types of things. But at no point did they state what the reasoning was behind this. So there's been a lot of speculation. Most recently, there was National Security Memorandum 20, right, where the U.S. Asked all countries that were providing munitions or defense supplies to provide assurances that they'll comply with international law, and that specifically they'll allow U.S. humanitarian aid in, and then to write reports on whether or not any of the provision of these materials or supplies are being used to violate international humanitarian law. But a second report specifically on whether or not countries follow civilian harm mitigation principles. And I mention that because there is a little bit of mix here between law and policy, and what the law and IHL actually requires, and then what are some of the policy constraints put on top of that may be additional civilian harm mitigation principles. And so for the U.S., we haven't signed we are not party to the arms trade treaty, but we have policy instead, things like the conventional arms transfer policy. We have the Civilian Harm Mitigation and Response Action Plan, and then the State Department's CHIRG. So a number of other things where we're doing policy here. And so it does look like the U.S. is finally changing its policy towards the provision of munitions, but they have not been clear on the reasons behind it. And NSM 20 required reports to be provided to Congress. The first one was due May 8th, specifically for countries involved in armed conflict, which would include Israel in this case. The U.S. government missed that deadline. So we don't know what they found and in what cases, but presumably some of that analysis is what is driving this decision. But I would just advocate for people to keep their eyes open on this evolving situation, because it does look like the U.S. policy on provision of arms may be changing going forward.
Thank you, Lauren. Ido.
Thank you. I'm going to be brief because we are almost out of time. I want to address a quick couple of points. I think I'm going to, in a way, complete a circle with my opening words and talk about two aspects. One is something I happen to somehow conclude it with every sessions we've had, the difference between Lex Lata and Lex Ferranda. We talked about, Omar Dajani talked about proportionality, referred to Yanina Deal's paper and addressed the notion of looking at proportionality in a wider scale. Sherry talked about violence not being the only solution, etc., and trying to look from different ways. I think we're on the same page that this is what we're aiming for. But as was said here, we are lawyers. The diplomats have their own job. We are lawyers. We look at what the law is saying right now. The law on proportionality does not look at the overall picture. We might want it. We might think it will end leading us to a better outcome. But at the moment, it doesn't do that. So we need to be very, very clear when you talk about what we want, what we're aiming for. versus what we can actually achieve at this moment. And with regard to the notion of the refugees and why Egypt refused, I think that going into pretty clear it was ethnic cleansing. That's the actually exactly right terminology that I'm referring to by a little bit drawing conclusions based on nothing thought that is not necessarily there. The international community, and that goes back to the diplomats, could have provided assurances to the return of Palestinians from Gaza to Gaza after the conflict was ended. On the same page, we could have argued that if they had been moving to Egypt, the war might have ended much quicker with much less suffering to the civilians in the Gaza Strip. We don't know. These are assumptions. And on the same assumptions, Omar Shakir with the upcoming report based on 8 incidents to say that it leads you to the conclusion that this was not a mistake. Well, this is again drawing conclusion. You don't have the complete without having the complete information. You can definitely conclude that there are suspicions of, but you cannot conclude that this is a genuine conclusion, that this is the approach taken by the IDF in that situation. And I do want to say again, thank you for the kind discussion, taking advantage of me being last again. And I really enjoyed that discussion. I think that we are able to have that discussion because of the auspices giving us by ASIL and the Labor Society. So I want to thank you again, Marianne.
Thank you all for a wonderful, civil, and critical discussion. We will continue it with our fifth session to be announced. Thank you to Taylor Kilpatrick and James Steiner of the American Society of International Law, to the Liber Society and the DC Bar International Law community. Thank you very much.